Good Friday morning, everyone. Welcome. If this is your first time, welcome. If you've been here before, welcome back. This is Michigan Crime Time, and I am your host, Jess. I just want to start with saying I am not an attorney. I am not making any legal conclusions nor putting forth any legal advice. All comments are my opinion, irregardless of any verbiage I may use. All persons are innocent until proven guilty in a court of law, and my videos are not the official record of the court. Okay, we got the official stuff out of the way. Good morning. It is Friday today. I'm going to start off with an Irish Demon video because I have not been online a lot lately. And Irish is my friend, and I kind of miss him. And the video is actually kind of funny. So we're going to start with that before we get into the more serious case. We're waiting on the court. It's scheduled for 9 a.m. I'm waiting for them to actually open up Zoom. So we will be in the official court Zoom. You guys will be watching that with me. Again, it is the verdict for the Oxford school shooter, Ethan Crumbley. He had a Miller hearing, which determines if he is eligible for life without the possibility of parole because he was just 15 years old when he murdered 4 students and shot 4 more students. Yeah, I know he shot a teacher. He pled guilty to 24 counts, including murder and terrorism, along with, I believe, some weapons charges. So he's already pled guilty, but the Miller hearing is to determine if he's eligible for life without parole, as that is first-degree murder here. In Michigan, we don't have the death penalty. Good morning, Glitter Fart. I have ice cold Coke Zero, not sponsored, but I'd love to be. I need the caffeine this morning. So let's go watch a fun video before things get really serious.
Savannah?
Okay.
Oh, poor kitty.
Yeah, he just threw a cat.
Sir, was that a cat you just threw?
Yeah, she comes down off. Sorry.
Okay.
Yeah, the
Sound
cat
like she hit
tosser.
kind of hard.
Now I'm one of those people who genuinely just loves animals. Well, I'm a dog guy. Now I'm sure I look like
Who is this handsome bastard? That beard, that handsome devil.
the kind of guy that has like a big German Shepherd or a Pit Bull or something like that. But no,
He has
I'm a Chihuahua
troubles.
dada. Mwah. I've got 2 of these little ones. The other one would not come out of bed though. He was too cozy. But she's a major daddy's girl, so she's always with me, sitting here next to my desk. To be fair, I usually have snacks, and that's probably why. For those who don't know, this is little Minnie Mouse. She's my baby. Mind you, she doesn't look too happy that I took her out of her bed. I think we'll put you back down, babes. And now, while I wouldn't say that I'm a massive cat lover, I'm not a cat hater either. And if I was looking after one or babysitting one, or if I had one, I'd treat it just as good as my Chihuahuas. Well, that's a barefaced lie. I would treat it really, really, really well, but never as good as my little babies. Anyway, this guy's got a cat, and I think somebody with a serious anger management problem like this fella definitely shouldn't have one. He's literally in court demonstrating that he doesn't have an anger problem. The cat literally did nothing.
Okay. Can you hear me?
I can, thank you, sir. We're on the record in 2022 CR 381 and 2023 CR 224, both captioned State of Kansas versus Christopher Lee Myers. Please announce appearances.
Jerry here on behalf of the state.
Joshua Andrews on behalf of Mr. Myers, who is also present.
And how does he wish to proceed on these 2 cases, Mr. Andrews?
Your Honor, at this time, we have entered into an agreement with the state. This Myers will enter a plea of no contest to the sole count
I'm sorry.
Now we're going to go out on a limb here and say that that ball was directed most likely at another completely innocent creature. But I may be wrong.
To the sole count of 22 CR 381, which is domestic battery, a Class B person misdemeanor. In exchange for the successful entry of that plea, the state will dismiss with prejudice case number 2023 CR 224 in its entirety. There will be a joint.
Okay, now that one is the DV battery violation protection order that will be dismissed with prejudice.
Yes, Your Honor.
And the other one, he's pleading guilty or no contest.
No contest, Your Honor.
Very well. Go
There will
ahead.
be a joint sentencing recommendation of a 6-month controlling sentence with 12 months reporting probation. As a condition of his probation, Mr. Myers will complete a battery intervention program assessment and follow any recommendations. Neither party is requesting a fine. There will be no contact with the victim, Crystal Cartmel, until Mr. Myers has completed the BIP assessment and then at the discretion of his court services officer.
Okay. Mr. Aguirre, that is your agreement?
Your Honor, in exchange for the successful entry of the plea in the 381 case, the state is prepared to conditionally dismiss the 224 case. My understanding is that upon successful conviction, the state would be recommending in the 381 case, no fine, $158 in court costs, $100 for the DV fund. I'll of course defer to the court on the issue of attorney fees. They would further recommend a 6-month underlying sentence, 12 months reporting probation, and a $60 probation fee. Besides,
Okay, this is live from the jail, apparently. I don't know if Ethan Crumbley is not going to be going in person, it sounds like. This is the Zoom from the court.
Hello?
They can't see me and I'm muted, just so you know. My name is listed as public. That's what it said to list. So it sounds like he's not going to even be in the courtroom today. That actually may not be a bad idea. Because I know when he was first arrested, he was pretty hysterical. I don't know if it's him that is making these rules. It may be the judge or his attorneys saying, no, you're going to do it from the jail. When they initially brought him in, like for questioning, because they arrested him on site. When they brought him in, I mean, he like was going berserk. I've got the video, some of the video of him in the holding cell or in interrogation. And I mean, he was going pretty bonkers. So it may honestly be a safety thing for staff so that he doesn't do something while in court to his attorneys, or he doesn't do something to himself or parents. I hate saying that, but we do know that survivors and parents of victims and survivors have been in court every day. It's, you know, it's probably more of a safety thing than anything is my guess. And honestly, it makes a lot of sense to me. But that was not him not participating. That was definitely, that's an order from someone else. It's honestly, with high profile cases, not uncommon. And this isn't sentencing. This is just the verdict from his Miller hearing. I'm probably the only one showing this. Oh, yeah, no, he will be there. He'll be there. This is the jail setting it up. They were asking if the court was there. This is literally, I am in the Zoom meeting, and this is the screen that's on the Zoom meeting. So he will be there from within the jail. They're just not transporting him to the courthouse, which is probably a safety thing. So he's still going to be there, just not in the courtroom. Let's go back to watching Irish Demon.
The state would also be recommending no contact with El Dorado Lake, no contact with the
I'll keep
victim
an eye
until
out on
after the
the
assessment is completed
court
and the
Zoom feed.
recommendations are begun, as well as all standard conditions.
Okay, thank you. Mr. Myers, is that your agreement?
I don't think he will. He has been fairly stoic through all of it. I mean, he literally sat there and listened to all the testimony from fellow classmates and the teacher that he shot, and he didn't whine. He's literally been there and present. Doesn't want to look at people, but he's still present, and he has not whined one bit. His parents, on the other hand, they're a whole different story.
Agreement.
Yes, was that, I thought he said 12 months probation, or was that 6 months?
I heard a 6-month suspended jail sentence in lieu of a 12-month reporting probation. Counsel, did I hear that right?
Yes, Your Honor.
So, Your Honor.
Mr. Myers?
Yeah, so I'll have to report for 12 months?
Well, if I accept your plea agreement, yeah.
I thought my lawyer said 6 months.
No, I told you 6-month controlling sentence with 12 months reporting probation.
Okay, well, what does that exactly mean?
Well, let's put you two back in the breakout room again. Savannah?
Okay.
Oh, poor kitty.
That poor cat, he just yeeted that thing
Sir,
across
was that
the
a
room.
cat you just threw?
Yeah, she comes down off, sorry.
Okay, sound like she hit me.
That
hard.
cop was like not amused.
All right, let's just look back on this for a second and see what exactly it was that the cat did that justified said cat being sent into orbit. Dramatic reconstruction. This is a slipper, not a cat.
Reenactment.
So the cat basically came from the site, minding its own damn business. He got pissed off and then yeeted the cat for nothing. Now, you might not like cats, but that didn't seem fair to me now, did it?
He's still in the breakout room. Let me try and get him back here.
Oh, apologies. Your Honor, I did speak with my client, and I do believe that he is prepared to accept the plea agreement as previously announced.
Mr. Myers, now that you've had more time to talk to your attorney, do you still wish to enter that no contest plea to the domestic violence battery in the 22 CR 381 in exchange for dismissal of the domestic battery and violation of protection order in 23 CR 224?
Yes, Your Honor.
And do you understand a no contest plea means you're not admitting the charge, but you're not denying it, you don't want to take it to trial?
Yes, ma'am. Yes, Your Honor.
In fact, do you understand that by entering a no contest plea, you're giving up your right to trial as well as your right to appeal any conviction?
Yes, Your Honor.
Now, has anyone made you enter this plea today by any kind of force, threat, or promise other than the terms of your plea agreement?
No, ma'am.
And you had some hesitancy before we went off the record and let you talk privately with your attorney.
Folks, just a quick break to ask you if you're enjoying this video. If you are, make sure and hit that thumbs up. Consider becoming a member or a Patreon or dropping a tip in the PayPal tip jar down below. Who knows? Maybe the Chihuahuas might get some treats out of it. And also, I want you to just stay tuned to the very end of this video. I've got a really important question to ask you guys, and I really, really, really want to hear your responses to it.
About the terms of the agreement. Do you feel satisfied with the terms now?
Yes, I understand.
And you wish to proceed with the plea agreement?
Yes, Your Honor.
All right. Mr. Regier, have you a factual basis to support the plea of no contest in 22 CR 381?
Yes, Your Honor. In reviewing the affidavit, it would appear the affiant, an officer with the Kansas Department of Wildlife and Parks on October 2nd of 2022, was advised of an incident, whereupon it was alleged that the defendant had struck the victim, who he had been in a dating relationship for approximately 1.5 years, 4 times across the face with an open fist. And I believe, and it looks like the address is, to which the affiant was dispatched was a campsite address in El Dorado State Park, all within the confines of Butler County, to my understanding.
All right, I accept that factual basis and find the defendant guilty, having accepted his plea of no contest is knowingly and voluntarily waived. Finding you guilty, Mr. Myers, I would ask the state if there's any recommendations other than what have already been stated.
None other than what have already been stated, Your Honor. And again, the successful conviction in the 381 case is a requirement for the dismissal per plea agreement of the 224 case.
All right, thank you. Mr. Myers.
Yeah, I never touched her. I threw a cup of water on her out at the lake. I won't take that.
No, Chris, remember we talked about.
I never struck and I never hit her once. I'm sorry. I can't. I'm not doing that. I'll take it to trial. I never touched her. I threw a cup of water on her.
That was the second case that was dismissed. I think that's.
All right.
I understand, Chris. We spoke benefits of the plea. Do we want to talk?
You want to talk privately again, Mr. Andrews? Or do you
Can I
want
talk
to
to
set trial?
Yes.
Let's put him back in the breakout room.
Yes, please.
Last time today, though. If this doesn't come to fruition, then we will set it for bench trial in October, which is just a hop and a skip.
Would I be able to get my ankle
you're-
monitor off because I can't?
Hold on, Mr. Myers. You're going to talk privately to your attorney about such matters. Savannah, please.
You need to click join, Mr. Myers, on your screen.
So obviously this guy is not an aggressive character. All he's done so far is throw something at somebody or something.
To the sole count.
Yeeted a cat.
Okay.
And as you can see, doing all these facial things, getting angry and stuff like that. But all he's ever done is dumped water on somebody. Clearly not an aggressive kind of character at all. I mean, how could you possibly think that somebody who turns a cat into a flying cat could possibly be an aggressive kind of character? So I'm sure he's going to fight this till the bitter end.
All right. Well, at this time, I am going to sentence you per your plea agreement to 6 months in the Butler County Jail. You will.
He really missed an opportunity to say a flying pussy, but yeah, that might have gotten him in trouble.
I'll have credit for time served on this case, not the one that's being dismissed, but on 381. I'm not going to give you a fine, but you will be ordered to pay court costs of $158, probation supervision fees of $60, and then a
That's it?
special fee of $100 to the Domestic Violence Offender Fund. Attorney's fees are waived. Probation will include all standard conditions, which probation will go over with you. You must call the probation department upon immediate completion of this hearing. And that number is 316-322-4153. Special conditions of probation include obtaining a certified domestic violence offender assessment. I think the parties have been referring to it as its other name, Batter's Intervention Program Evaluation. But you have to get that evaluation and then you have to comply with whatever it recommends, if anything. You are to have that appointment scheduled within 1 week. Now, you don't have to have the evaluation in 1 week. That's a little bit too much to be expected, but you have to be on the phone calling the evaluation facility and setting it up. Probation can give you some places to call for that.
Okay. Do they do that? I'm sorry.
I'm not sure where they do it, if they do it locally or not. They have in the past, they have not in the past. I'm not sure the current status, but probation will.
Okay.
And no contact with the El Dorado Lake where this happened. No contact with Crystal Cartmill. Are you two still considered in some kind of relationship?
Yeah, we were supposed to be getting married.
Okay, but you're not anymore. This happened October 22. Are you still planning to get married?
We really haven't seen each other much in a year, so I mean, it's not. I don't.
Okay. Well, I'm going to order no contact with Crystal Cartmill. And I think that covers the plea agreement. Mr. Regier, anything further?
1 moment, Your Honor.
Your Honor, one Mr. Gears looking, I was going to say, just for clarification, the plea agreement was no contact with Ms. Cartmell until after the BIP assessment and at the discretion of court services. I just,
Fine. That's fine. We can put that in there. I thought if he's not having a relationship with her in a year, he doesn't need to have one, but I'm afraid I assume she was the alleged victim in the case that's being dismissed, the violation of protection order and DVBAT.
yes, Your Honor.
I just don't, after a year's time, I don't want him to show up and then the two of them get in another issue again. So I was gonna just say no contest, but I'll use your language, and as long as he doesn't get a new charge.
Thank you, Your Honor.
You're welcome. If you'll be extra cautious in advising him about that.
Yes, Your Honor.
Mr. Regier, did you get that change in order from no contact to no contact and until after the evaluation and at the discretion of probation?
Yes, Your Honor. Is the court also ordering all standard conditions, and also if the court is ordering a $6 probation fee? I don't know if the court has a specific time frame in mind for the length of probation. Safe recommendation pursuant to the plea would be 12 months.
12 months is the length of reporting probation. Defendant is ordered to pay 1/12 at least of the total due each month to get this paid. That should be easily workable. If not, talk to your probation officer, but that's my order at this time. Anything else, Mr. Regier?
Your Honor, does the court want to, for that 1/12 payment, does the court want to set a beginning date for that, or is the court also leaving that to the court's
Well,
discretion?
let's start that. It's October 31st. If he pays online, otherwise by the close of business, I'd just say October 31st, it has to be paid by.
Very good, Your Honor.
Okay, if there's nothing further, then Mr. Myers, the other case, 23 CR 224 is dismissed with prejudice as part of your plea agreement. Go call your probation officer and do well.
How much is all the font or everything costing?
Looks like it's about 318 if my rough math is right. 318.
Okay.
Thank you, Mr. Myers. Thank you, Mr. Andrews and Mr. Regier. All right, Mr. Andrews, I think that concludes your appearances.
As far as I know, it does, Your Honor.
All right, thank you. Then Mr. Andrews is excused. Mr. Myers is excused with the condition that he call his probation officer.
Thank you, Your Honor.
Thank you.
Do I have the same probation officer that I'm seeing now?
You'll have to ask them.
Okay. All right.
Thank you.
So about halfway through the video, I asked you guys to stay here and let me know what you think about something. And here's the question I have for you. Yes, cats usually, because I've seen situations where they haven't sadly, but usually cats land on their feet. Now, in this scenario, it seems like the cat was relatively unharmed, still not a very nice situation. Would you agree with me that what we just witnessed was animal abuse from somebody who is in court
Yes.
for human abuse? If that's the case, do you think he should be prosecuted for it? I'd love to hear what you have to say down below. Well, there we have it, folks. Seems like the only pussy this guy got eaten across
Oh,
the
I
room.
get it.
I suppose some people are kind of into that kind of thing, but in any event, it does seem to me like this guy has a bit of an anger problem. Taking it out on a sweet little cat like that just seemed to be completely unnecessary. People like that probably shouldn't be allowed to keep animals. As I said, I absolutely adore animals of all shapes and sizes, all types, all kind of characters, you name it. I love them. I'm lucky enough to live on this big, beautiful farm where we've got loads of different types of animals. Anything from chihuahuas up to massive 1,000-pound horses and cows and birds of all description. I've even got some little shrimp right here on my desk. Loads of fish out there, like a bit of everything. So when I see somebody do something like that unnecessarily to an animal, it really, really bothers me. And I hate to see people like that being allowed to have animals in the first place. Anyway, folks, thank you for joining me. I really, really hope you enjoyed the video. If you did, make sure and smash that thumbs up button and we'll catch you in the next one. Sláinte.
Forgot to unmute myself first. Okay, so we are still waiting on the court to start. It should start within the next 4 minutes. So I don't know I normally don't have a problem with having something to talk about, but I didn't sleep last night, so I'm tired. I don't know, you guys watching, you have any questions for me? Throw them in the chat. I'll answer questions. Why not? It could be fun or dangerous or weird. I don't know. And I don't think I have any I don't have anything loaded as far as clips go. So I honestly, I thought court was going to start I had it in my brain that it started at 8:30 this morning. So I scheduled to start at 8:30 thinking that's what time court would start. No, that's what I get for thinking. That is what I get for thinking, guys. I do have to do the last little bits of his Miller hearing still. If you guys have been around for a while, you know that I have some fairly major, serious chronic health issues, and I've been dealing with that. So I haven't been around as much. I've been just in and out of doctor's appointments, so I really haven't had a whole lot of time or spoons to do a lot of court stuff. It's been, yeah. But I'm on the upswing of things, so that's good. I actually will be in Ann Arbor next Thursday, and I want to stop by Judge Simpson's courtroom because I would like to meet him, or at least see him live in action. I couldn't record while I'm there because I don't have any motions filed and I don't know any cases that would be heard on Thursday. But it'd be cool if I could go and get a picture with him. I'm seeing the neurosurgeon at the University of Michigan, the surgeon that did my spinal fusion. I have to see him again. I need more vertebrae fused, so I have to go back. So I'm going to be in the area, so I would like to stop by and see Judge Simpson. Although I'm not sure if he's in Ann Arbor or if he's in Ypsilanti, but they're right next to each other, so they're not that far apart. I've heard both. Like, the website says he's in Ann Arbor, and then other people that are from Ypsilanti and Ann Arbor, they say he's in Ypsilanti. I don't know. It's craziness. So I guess my last live stream, I showed off my Antique Singer sewing machine, and she's still sitting right here. I'm still working on my ribbon skirt. But are you guys interested in, like, watching me craft while I do videos? I mean, is that even like crafting in crime? Is that even a thing? I've never seen that before, but I guess I could do that every once in a while where I do some crafting thing. I mean, I'm always knitting or something while I'm streaming or editing anyways. So it would just be a matter of setting up a camera angle to get whatever I'm working on. I can tell you this is a hat for, well, we're not related by blood. Oh, here we go. And his attorney is there with him in the jail. Anyways, I call her my niece. My friend is a Nupik, which is Alaskan Native. I have the big anti-energy from the res, even though I'm not from the res. And I made her sweaters, and I had leftover yarn, so I'm working on hats for her so she can match, because they live in Alaska and it's cold up there. It's going to snow soon. So she needs sweaters. And it's really easy. Do whatever I want and makes you happy. Okay. That would be sleeping right now. No. I am very tired. I've done it with the camera where you guys have watched me spin yarn while I'm streaming. I suppose it just
This
depends
meeting
on
is
my
being
nature.
recorded.
Your Honor, calling People versus Ethan Crumley, case number 2022-279-506 FC.
Thank you, and good morning, counsel. Appearances for the record. When you give your appearance, please indicate whether or not you consent to proceed via Zoom this morning.
Thank you, Judge Mark Keeston, on behalf of the people. The people did consent to this hearing being held via Zoom.
Karen McDonald on behalf of the people.
Paula Michelle Lofton on behalf of Ethan Crumley, who's sitting to my left. Amy Hopp on behalf of Ethan Crumley. Deborah H. McKelvey on behalf of Ethan Crumley.
Thank you, and good morning to all counsel. Mr. Crumbley, are you okay with proceeding via Zoom this morning?
Yes, sir.
Thank you. With that, today's date and time is set for the court's decision on the Miller hearing that was conducted approximately a month ago. Before we get to the court's decision, we do need to address the Juvenile Justice and Delinquency Prevention Act. With that, any argument as it relates to defendant's placement at this time from the people?
Thank you, Judge. We did file a memorandum of law. We do believe that the defendant is in the appropriate placement at this time.
Thank you. Defense, anything to add?
No, Your Honor, we have no objection to the current placement.
Thank you. With that, the court does believe that it continues to be in the interest of justice to continue the defendant's placement at the Oakland County Jail. With that, the court has prepared a written opinion and order in this case. I will file the written opinion and order after I have read it this morning. Please note that I am not going to read all of my citations into the record. If you wish to see the court citations, it will be within the opinion and order. With that, this matter is before the court on the prosecution's motion seeking life without possibility of parole, filed on November 14th, 2022 for defendant Ethan Crumley. The court notes that the prosecution's motion was filed timely pursuant to MCL 769.25(3). On October 24th, 2022, defendant pleaded guilty to 24 felony counts, including 1 count of terrorism causing death, 4 counts of first-degree premeditated murder, 7 counts of assault with intent to murder, and 12 counts of felony firearm. Defendant was 15 years old at the time of the offense. Therefore, the court is required to conduct a Miller hearing before determining whether to sentence defendant to life without parole or a term of years. The court conducted the Miller hearing, and this opinion and order follows. A basic precept of justice requires that punishment must be proportionate to both the offense and the offender. In Miller, our United States Supreme Court struck down mandatory life without possibility of parole sentences when the offender was under 18 years old. The Supreme Court has long recognized that children are constitutionally different from adults for sentencing purposes. Sentencing a child to life without parole is excessive for all but the rare offender whose crime reflects irreparable corruption. Miller requires that before sentencing a juvenile to life without parole, the sentencing judge take into account how children are different and how those differences counsel against irrevocably sentencing them to lifetime in prison. The court recognized that a sentencer might encounter the rare juvenile offender who exhibits such irretrievable depravity that rehabilitation is impossible and life without parole is justified. But in light of a child's diminished culpability and heightened capacity for change, Miller made clear that the appropriate occasions for sentencing juveniles to the harshest possible penalty will be uncommon. In Jones versus Mississippi, the United States Supreme Court confirmed that Miller did not impose a formal fact-finding requirement and added that a finding of fact regarding a child's incorrigibility is not required. If the Miller or Montgomery court wanted to require sentencers to also make a factual finding of permanent incorrigibility, the court easily could have said so, and surely would have said so. The United States Supreme Court set forth the circumstances that a trial court should consider before concluding that it is appropriate to sentence a juvenile offender to die in prison. The circumstances that a trial court must consider are called the Miller factors. The Miller factors are: 1, the juvenile's chronological age and its hallmark features, among them immaturity, impetuosity, and failure to appreciate risk and consequences. 2, the juvenile's family and home environment from which he cannot usually extricate himself, no matter how brutal or dysfunctional. 3, the circumstances of the homicide offense, including the extent of his participation in the conduct and the way familial and peer pressures may affect him. 4, the incompetencies of youth, which affect whether the juvenile might have been charged with and convicted of a lesser crime. For example, because the juvenile was unable to deal with law enforcement or prosecutors, or because the juvenile did not have the capacity to assist their attorney in their own defense. And 5, the juvenile's possibility of rehabilitation. In Michigan, the prosecutor must move the court to impose a sentence of life without parole for a juvenile, and if it does, then the court shall conduct a hearing on the motion as part of the sentencing process. At the Miller hearing, under Section 6, the court shall specify on the record the aggravating and mitigating circumstances considered by the court and the court's reasons supporting the sentence imposed. The court may consider evidence presented at trial together with any evidence presented at the sentencing hearing. Each victim must be afforded the right to appear before the court and make an oral impact statement at any sentencing or resentencing of the defendant. The court notes that the defendant has pleaded to terrorism causing death, which has approximately 2,000 or more victims. As such, the court found it necessary to adjourn sentencing out far enough so that the Michigan Department of Corrections would have enough time to prepare the precinct's investigation report and contact any victims who may want to make a statement to the court. The court scheduled sentencing for December 8, 2023. At that time, the court will have a completed precinct's investigation report and will also hear from victims. The purpose of this opinion and order is to simply decide whether the prosecution has met its burden by clear and convincing evidence that life without parole is not disproportionate. If the court decides not to sentence an individual to imprisonment for life without parole eligibility, the court shall sentence the individual to a term of imprisonment for which the maximum term shall not be less than 60 years and the minimum term shall not be less than 25 years or more than 40 years. Miller's substantive holding is that life without parole is an excessive sentence for children whose crime reflect transient immaturity. Taken together, Miller and MCL 769.25 create a rebuttable presumption against life without parole sentences for juvenile offenders. As a procedural mechanism, therefore, it makes sense for a sentencing court to start from the premise that the juvenile defendant before them, like most juveniles, has engaged in criminality because of transient immaturity, not irreparable corruption. The Taylor Court found that the court need not make any particular finding of fact, but that it does not relieve the prosecutor of the burden of demonstrating facts that support their extraordinary request to sentence a juvenile defendant to life without parole. Additionally, the Taylor court found that the prosecutor must prove facts and circumstances that rebut the presumption against life without parole by the well-known standard of clear and convincing evidence. The trial court must consider all the evidence before it and determine whether the presumption has been rebutted to impose life without parole. This is an exercise in discretion, not a fact-finding mission. There is no particular fact that a prosecutor must prove to establish that life without parole is appropriate. The Taylor court cautioned the trial court's use of the Miller factors and stated, "We take this opportunity, however, to reiterate that it is undisputed that all of the Miller factors are mitigating factors. If a particular Miller factor does not militate against life without parole, for example, at most, that factor will be considered as neutral." The court again cautioned that trial courts are to ensure that Miller factors are not used as aggravators. Here, over the course of 4 days, this court held a lengthy Miller hearing. Both the prosecution and defense called witnesses, and the court admitted numerous exhibits. Taylor does not require this court to make any particular findings of fact. Therefore, the court will focus on the Miller factors and the evidence that mitigates each factor, as the Taylor court cautioned. The court will begin its analysis regarding the first Miller factor, the juvenile's chronological age and its hallmark features, including immaturity, impetuosity, and the failure to appreciate risk and consequences. First, this court finds that defendant's age is a mitigating factor. There is no dispute that at the time defendant committed the underlying offense, he was 15 years and 6 months old. The court will focus its analysis regarding defendant's age based upon the testimony of Dr. Daniel P. Keating, who was qualified as an expert in adolescent brain development. Dr. Keating testified that he has conducted research in developmental science broadly, but has specifically focused on adolescent brain development and adolescent neural development. He has been involved in research regarding early childhood development and effects of early life diversity on the life course. He has never met defendant. In sum, Dr. Keating testified that until a person reaches their early 20s, the limbic system or bottom brain shows a period of very high activation, hyperactivation, beginning in middle adolescence and carrying on until their early 20s. And so the incentive and the reward-seeking system is at a height during that period of time. Dr. Keating described defendant's brain at the time of the offense as an adolescent brain. An individual possesses an adolescent brain between age 11 and 24 years old. The court also notes that defendant is at just 15 years old and not had much life experience. Additionally, because of his age, defendant relied on the care and support of adults, primarily from his parents. He could not make major life decisions without the approval of his parents or an adult. As such, the court finds his age is a mitigating factor. Next, the court finds defendant's maturity is a neutral factor. Although the court finds that defendant's age is a mitigating factor, his age alone does not persuade this court that his maturity is a mitigating factor. In this case, defendant's age and maturity do not go hand in hand. Prior to the shooting, defendant appeared as mature, if not more mature than those his age. He was employed at age 14 at a diner near his home. He worked until September of 2021, 2 months prior to the shooting, when he and his parents decided to allow defendant more time to focus on improving his grades in school. Defendant participated in bowling and wanted to make bowling his career. Bowling was briefly canceled due to COVID-19, but he returned to bowling in late fall of 2020. Defendant indicated that between work, homework, and playing video games, he could not find time to do other stuff. Defendant has been described as a person with average to above average intelligence. Defendant advised Dr. Anneker that in August 2021, he persuaded his father to get him a new gun, a .22 Derringer two-shot. Defendant paid for the gun with his own money. Defendant also advised that he persuaded his father to buy him a 9mm pistol that was ultimately used in the shooting. Defendant advised his father bought the gun with the defendant's money. Defendant practiced at the gun range shooting the gun with his mother and showed his mother how to use the gun. This does not illustrate the hallmark immaturity of a child. Further, the defendant had mature thoughts regarding how society functions that do not align with immaturity. In defendant's journal, he discusses his view of the American school system. In part, defendant stated, "I'm already forced to wake up at 6:30, 5 days a week, and be bored out of my mind for 7 hours straight, and I'm not going to let some self-centered snowflake bitches tell me if I'm allowed to talk or whether I have to put my head down or not. It's straight up fucking retarded. And when I talk about this to people at school, they don't understand what I'm saying. But when I talk about this to an adult, they understand. It's basically like I found out the truth early, and I guess the people who work in the school don't like that and try to force school is life on me." Defendant reiterated same or similar feelings in a video he recorded the night before the shooting. In the video, he weighed his future employment prospects, including joining the military. He even weighed the pros and cons of joining the military. The court finds that the defendant is mature. He can weigh the pros and cons of future employment, how he would live his life, and whether he would be happy in any career. Unlike immature children or teenagers, the defendant thought in depth about his future and how he fits into the world. To be clear, the court is not saying that teenagers cannot or do not think about their futures, but the level of defendant's in-depth thoughts about his future leads this court to believe that he is not immature or has the hallmark immaturity of a child. Lastly, he had been employed, participated in bowling with friends, and was able to convince his parents to buy him 2 guns and practice at a gun range. As will be discussed below, the defendant conducted significant research before he committed the underlying crime, including the type of weapon he would use and possible criminal penalties. Defendant's thorough planning and research does not reflect hallmark immaturity of youth. Taken together, the defendant appears more mature than others his age. His thought process, actions, and statements do not align with the hallmarks of youthful immaturity. As such, the court finds his maturity is a neutral factor. Next, the court finds defendant's impetuosity and potential failure to appreciate the risk and consequences of his actions are neutral factors. Dr. Keating provided the court with ample testimony regarding adolescent brain development and brain maturity. Dr. Keating testified that there are specific hallmarks of adolescent brain development, which include development of the limbic system, bottom brain, the frontal vortex, and ultimately the prefrontal system, the top brain, the relationship between the bottom brain and the top brain, and the period of extremely high neuroplasticity. The prefrontal cortex is responsible for executive functions, which is the ability to think through things in a systematic way, to focus attention, and to shift attention appropriately. The prefrontal cortex is the primary way that individuals learn to inhibit impulsive or impetuous behavior. Further, an adolescent brain continues to develop until it reaches maturity, which is in one's mid-20s. By age 16, adolescents are not very different from adults in their ability to do things like solve logic problems. The prefrontal cortex has limited capacity. When fully engaged in one's task involving effortful control, it has limited or no capacity to undertake additional tasks that require judgment. This has 2 implications. 1, having embarked on a plan to undertake a risky behavior, the execution of that plan may use up the available prefrontal cortex resources, further compromising the adolescent's ability to adjust behavior when circumstances warrant. 2, engagement with other activities that demand prefrontal cortex resources, such as dealing with emotionally arousing situations or in the face of peer pressure, may make the limited prefrontal cortex resource effectively unavailable. Until the adolescent brain matures, the ability of the rational, analytic judgment and governance functions of the prefrontal cortex to override unanalyzed poor decision-making is limited. The limbic system, also known as the bottom brain, is responsible for emotional and hot cognition elements that go into decision-making. The decision-making for an adolescent depends on the interaction between the prefrontal cortex and the limbic system. An adolescent brain has less ability to inhibit and control behavior that is impacted by hormonal changes associated with puberty. By age 15 or 16, adolescents can respond accurately to how risky various scenarios are. Their ability is diminished when aroused. The weighting that adolescents give to the benefits compared to the minuses that they give to the risks tend to be substantially weighted more towards benefit rather than looking at the risk in adolescents compared to adults. The fact that there was planning or premeditation before committing a crime does not change Dr. Keating's finding that an adolescent brain functions differently than an adult brain. Specifically, Dr. Keating testified in part that the fact of planning obviously means that it's not an impulsive split-second decision to do something, but it doesn't necessarily mean that it's not an impetuous plan that has been carried out. It is difficult for an adolescent to deviate from a plan, even a bad one. Dr. Keating described the process as analogous to getting on a train that is headed in a bad direction and trying to find a way to get off of a runaway train. For adolescents, finding an exit ramp is much harder than it is for adults. Dr. Colin King testified that the defendant is mentally ill. The court qualified Dr. King as an expert in mental health and forensic psychology. Dr. King became involved in this case in December of 2022. He spent 23 to 24 hours testing the defendant over the course of 6 virtual sessions using 15 different assessment tools. Additionally, he reviewed a litany of records, including police reports, defendant's schoolwork, defendant's text messages between the dates of April 5th, 2021 through April 7th, 2021, Oakland County Sheriff's statement from 2 students, videos of the shooting, the bird video, and defendant's manifesto. Having reviewed the records, Dr. King concluded that a review of defendant's text messages months preceding his arrest and charges indicates that he was experiencing severe paranoia, delusions, and hallucinations. Dr. King noted that defendant meets the criteria for the following disorders: major depressive disorder, severe with psychotic features, generalized anxiety disorder, and obsessive compulsive disorder. In contrast, Dr. Lisa Anaker testified that at the time of the offense, defendant did not meet the statutory definition of mentally ill. The court qualified Dr. Anaker as an expert in forensic psychiatry. Dr. Anaker's understanding of Michigan definition of mental illness is that it is a substantial disorder of thought or mood that significantly impairs a person's judgment, behavior, capacity to recognize reality, or ability to cope with ordinary demands of life. On March 15, 2022, Dr. Anaker evaluated the defendant relative to his criminal responsibility. The evaluation lasted approximately 5 hours. Prior to interviewing and evaluating the defendant, Dr. Anaker consulted with defense counsel and the prosecution, reviewed police reports, Federal Bureau of Investigation interviews, U.S. Department of Justice reports, defendant's written or drawn material, videos, and a host of other information as outlined in pages 1 through 6 of her written report. Defendant advised Dr. Anaker that he had never been formally involved in mental health treatment prior to the alleged offense. Prior to the offense, defendant described having low mood, lack of motivation, low energy, occasional anhedonia, which is the inability to feel pleasure, suicidal thoughts, and a suicide attempt in October of 2021, and decreased appetite. Additionally, he described hearing both external and internal voices and had frequent hallucinations. Nevertheless, Dr. Anaker noted that a person can have anxiety or depression and can see a therapist, and they might not meet the criteria for statutorily defined mental illness because it does not rise to the threshold of a substantial disorder of thought or mood. Dr. Anaker disagreed with Dr. King's diagnosis of major depressive disorder severe with psychotic features because Dr. King relied heavily on subjective data instead of objective data. Dr. Anaker stated that it would be incredibly atypical for someone who was acutely psychotic to then show no signs of psychosis, both during the shooting, immediately after the shooting, and then for months after in the jail without treatment. Additionally, defendant advised Dr. Anker that he was not hallucinating at the time of the shooting, nor did he hallucinate in the days prior to the shooting. He denied command hallucinations, which are voices that command a person to do something. Importantly, defendant did not attribute any of his behavior to delusions or psychosis. Dr. Anker did not contest that defendant had low mood, but disagreed that he met the level of functional impairment that is necessary for a major depressive disorder diagnosis. Here, there is no reasonable dispute that defendant planned to kill multiple people at Oxford High School. Defendant documented his plan in a journal, including who he would kill first, a pretty girl with a future. Defendant's journal is 22 pages long. Lieutenant Timothy Willis testified that all 22 pages in the journal referred to the school shooting. On page 22 of the journal, defendant wrote, "I want to shoot up the fucking school so badly. Soon, I'm going to buy a 9mm pistol." Additionally, he wrote that he would shoot anyone he sees and that he would aim for the head until he had to reload, that he would find a full class, and throw a Molotov cocktail in there. He wrote that he would continue to shoot people until the police breached the building, and then he would surrender and spend the rest of his life in prison. Defendant did not plan on killing teachers, but planned to kill a specific teacher. He wrote in part, "I'm sorry for this, Mom and Dad. I'm not trying to hurt you by doing this. I have to do this. This is the last passage I write. It's currently 29/11/2021, 1:23, exactly one day before the shooting." Defendant planned to cause the biggest school shooting in Michigan. He did not want to kill himself because he wanted to see the world react to the shooting. The court has reviewed what has been referred to as defendant's statement of intent video dated November 29th, 2021, the night before the shooting. The first video is approximately 19 minutes and 59 seconds long. In general, defendant confirmed that he was going to do the school shooting and gave reasons why. Defendant knew the possible consequences of his actions because he conducted research regarding possible penalties. He conducted research regarding other school shootings. Defendant's web history shows that he searched for, should you do something that can imprison you? Should you do something that scares you? Aftermath of the deadly shooting at Stoneman Douglas High School in Parkland, Florida. What is the worst prison sentence you can get in Michigan? This was searched for 4 times. What is a life sentence for a 15-year-old? This was searched for 3 times. What is the legal age to be sent to prison? Michigan Youth Correctional Facility. What prisons are there in Michigan? Has anyone ever been executed in Michigan? What states have the death penalty? Is Nicholas Cruz sentenced to death? What does maximum death penalty mean? Further, defendant researched and considered the type of gun and ammunition that he would use during the shooting. In defendant's journal, he wrote, "So now I'm pissed because I want to do the shooting with a 9mm pistol, as they are effective for killing. But right now, all I got is a CUNY 22 LR Kel-Tec that I don't know where my dad hid it." In his journal, defendant drew 2 separate rounds of bullets. He specified that the kill range for a 22 caliber rifle is 25 meters maximum, whereas the kill range for a 9mm parabellum pistol, 100 meters. On multiple occasions, the defendant practiced shooting a gun at a shooting range. Additionally, in preparation for the shooting, defendant researched the school's layout and downloaded a map of Oxford High School. The map showed locations of classrooms, restrooms, entrances, and exits. Prior to downloading the school map, he conducted an internet search regarding the average police response time for a shooting. He created a list of items needed for the shooting that included a 9mm pistol, 2 to 5 Molotov cocktails, 1 to 3 powered NOS flares, a pair of gloves, hat, jacket, mask, and a knife. While at the school, but prior to the shooting, defendant plugged his ears with tissue paper to muffle the gunshot noise. Not only did defendant plan every action, but he also followed through with his plan. First, defendant shot Phoebe Arthur and Elijah Mueller, who were shot in the face and neck area. He then shot John Ocedo, who was running for his life. He then shot Kylie Faye, Riley Franz, and he killed Hannah St. Juliana. Defendant shot and killed Madison Baldwin. He shot Tate Muir in the back of the head from approximately 100 feet away, killing him. He walked past an occupied classroom, turned around, and fired several shots into an office, shooting Molly Darnell. Aiden Watson was shot as he was running for his life. Defendant killed Justin Schilling in the restroom. All in all, defendant killed 4 people and injured 7 others. Again, this court finds impetuosity and potential failure to appreciate the risks and consequences of his actions are neutral factors. The court cannot find impetuosity mitigating here based upon defendant's significant plan to conduct the school shooting. The court notes that defendant may have had a mental illness, but that does not persuade the court that this factor is mitigated. As outlined, he researched the weapon he would use, he downloaded a map of the high school, he put tissue in his ears to protect himself prior to the shooting, and he methodically shot and killed several individuals with precision after having practiced at a gun range. This is not a case where the defendant had no time to think about what he was going to do. He had several opportunities to not conduct the school shooting, but he went through with it anyway. Additionally, he had several opportunities to stop the school shooting during the incident, but he did not. After shooting the first person, he was not deterred from shooting others. The defendant's decision to conduct the school shooting was not an impulsive or impetuous decision. It was a thoroughly thoughtful one. Next, he appreciated the risks and consequences of his actions. How can this court possibly find mitigating that defendant did not appreciate the risks and consequences of his actions, where defendant said he would spend the rest of his life in prison and even wrote about it and conducted significant research regarding a potential prison sentence? Defendant wrote in his journal, "I'm probably going to spend the rest of my life in prison. I hope I can talk to someone though, so I don't take my anger out on the other prisoners." As outlined above, he conducted significant research regarding possible criminal penalties. In one internet search, he specifically searched what is a life sentence for a 15-year-old on 3 different occasions, and what is the worst prison sentence you can get in Michigan on 4 different occasions, albeit the searches were conducted on the same day. Presumably, the defendant would have received a response to his internet search that would have advised him of the possible penalties. He even researched Michigan prisons. Additionally, he researched other school shooters and their sentences. He knew the full outcome of his actions and appreciated the consequences. Dr. Keating testified that an adolescent's ability to override unanalyzed poor decision-making is limited. But here, defendant analyzed every action that he would take. Defendant certainly analyzed his poor decision to conduct the school shooting, so his ability to override the best decision should not have been limited. In sum, impetuosity and potential failure to appreciate the risks and consequences of his actions are neutral factors. Next, the court finds that the juvenile's family and home environment from which he cannot usually extricate himself, no matter how brutal or dysfunctional, are mitigating factors. There is no question that defendant's home environment was not ideal. Prior to the offense, defendant was a resident of Oxford, Michigan. In 2020, Oxford, Michigan had a population of 3.5 thousand people with a median age of 43 and a median household income of $67,130. Defendant's family fit the profile of the average family in Oxford. The court reviewed defendant's admitted Exhibit B, which is Dr. Jillian Peterson's report from the Violence Project. Dr. Peterson is the co-founder and co-president of the Violence Project Research, which is known for its public database of mass shooters in the United States. Dr. Peterson outlined in her report that witnesses will testify about defendant's early childhood growing up in Washington State. Multiple neighbors heard yelling, screaming, smacking, and crying coming from inside the Crumbley's various residences on multiple occasions. Neighbors thought there was domestic violence happening, complained to management, and even called the police. Friends and neighbors witnessed defendant punished violently by James and Jennifer Crumbley. Defendant's elementary school teachers will testify that James and Jennifer Crumbley were not active in his education. Witnesses will testify that daily fighting continued into defendant's adolescence up until the time of the shooting. James and Jennifer Crumbley fought loudly on a daily basis until late in the night and early mornings. They were often intoxicated during these altercations. The court notes that over the course of the 4-day Miller hearing, it did not hear from any of the witnesses that Dr. Peterson outlined. Nevertheless, Dr. Peterson's report is consistent with Dr. Colin King's testimony regarding the defendant's upbringing and home environment prior to the shooting. The court finds that defendant's parents neglected him. As early as age 6, defendant was left home alone. Dr. King interviewed a neighbor who advised that defendant would go across the street to the neighbor's home, especially during thunder showers, to report that he was afraid and would ask for help. While at home alone, defendant spent countless hours playing video games and spent an inordinate amount of time going to different websites and indulging in various graphic media. Defendant began to fantasize about being a part of violent scenes. Dr. King referred to defendant as a feral child. He defined feral child as a child who has been abandoned. Dr. King profiled defendant as a feral child because he had high levels of isolation, lack of parental support, lack of guidance, and lack of resources. Despite requesting mental health care, his parents failed to take him for a psychological medical evaluation. In Dr. Anika's report, she stated, while Mr. Crumbley denied any formal mental health treatment prior to the alleged offenses, he recalled requesting mental health care within the last year. He noted on his 15th birthday, he got really upset and said, "I want to see a therapist." He was asked why he wanted to see a therapist at that time and stated, "I guess I didn't want to move forward in life. I wanted to stay at that point. So when I realized I'm getting older, I needed help to get past that." He stated his mother reportedly said, "All right, I'll get you someone you can talk to." Defendant stated, "It never really happened and I forgot about it." Defendant's father bought him a gun that was ultimately used in the school shooting, despite knowing defendant needed a psychological and medical evaluation. Defendant's aunt and step-grandmother submitted letters to this court's review. For this court's review, that's defendant's Exhibit T. The court has read both letters. Defendant's aunt has been in weekly contact with him since incarceration in November of 2021. He has also had almost weekly contact with his step-grandmother. Defendant's aunt visited him in July of 2021. She describes him as an individual who possesses several remarkable traits. Defendant's aunt wrote to the court, "In my opinion, Ethan had a good childhood, filled with love, family vacations, and happy memories." The last time she saw the defendant was in July of 2021. She described him as very helpful and respectful and assisted her in any way needed. They had a great conversation regarding his employment and pets. He even advised his aunt how he nursed an abandoned kitten back to health. This was 4 months prior to the shooting. Both his aunt and step-grandmother continued to support him. Per defendant, he did not experience trauma or abuse growing up. The defendant provided Dr. Anika with historical information regarding his upbringing and home environment. Dr. Anika reported that Mr. Crumbley was asked if he experienced trauma or abuse growing up. He denied this. He was asked specifically about a witness statement from a student at Oxford High School in which she told police that Mr. Crumbley had informed her that his father shot him with BB guns on a regular basis. He responded, "I lied about that." He stated he had indeed told his classmate that his father shot him with BB guns, but indicated he only told her in an attempt to relate with her and her own struggles. He again denied any experience of physical, sexual, or emotional abuse. He instead recalled pleasant memories of camping with his parents and owning a wide variety of animals at their home, including a ferret, rabbit, chinchilla, and various cats and dogs. There is conflicting evidence regarding the defendant's home environment. Therefore, the court places little to moderate weight on this factor. For example, the defendant reports that his childhood was good, but Dr. King referred to the defendant as a feral child. Dr. King reported that the defendant's physical abuse was debatable, but the defendant denied any history of physical abuse. Dr. King reported that the defendant suffered from trauma, but the defendant denied any history of trauma. Dr. King reported that the defendant suffered emotional abuse, but the defendant denied any history of emotional abuse. Dr. King advised that the defendant's parents abandoned him, but they both discussed trying to get the defendant's school counselor to talk to him. Further, multiple texts from the defendant's mother show that she took interest in how the defendant was doing, whether he made it home from school, and whether he had eaten before work, because she did not want him to go to work feeling unwell. For example, the defendant's mother texts his father, "Is he being weird and depressed?" However crude, it shows an interest in defendant's well-being. Defendant's mother showed an interest in how defendant was doing and communicated those issues to defendant's father. Therefore, it does not appear to this court that defendant was a feral child as Dr. King described. Nevertheless, defendant's parents failed to get him the psychological medical evaluation that he needed, despite defendant asking for help. Defendant was exposed to substance abuse, but he denied that it negatively impacted him. In fact, he stated that he viewed his parents as a reminder of what not to do, and specifically looked to his father as what not to do, so he never touched, quote, weed, unquote, or alcohol. Indeed, it appears that his parents' consumption of alcohol contributed to their neglect, but it does not appear the defendant was significantly affected. So the court finds that defendant's parents' substance abuse minimally impacted the defendant. The court finds that his parents' neglect is a mitigating factor. However, his general home life, while not ideal, was also not terrible. Despite his parents' shortcomings, the defendant appeared to have a loving and supportive family. He went on family vacations, owned several pets, and had visits from family. He had housing, lights, gas, water, and by his own statement, he was not subject to physical or sexual abuse. In defendant's own words, his childhood was good. In sum, the court finds that defendant's parents frequently left him alone since an early age, that his parents frequently used alcohol and argued in front of the defendant, that his parents failed to take his mental health seriously, and that his father bought him a gun that he used in the school shooting. Taken together, defendant's family and home environments are mitigating factors. The court finds the circumstances of the homicide offense are neutral factors. There is no doubt that the defendant committed a premeditated heinous crime. There is no need to be repetitive. The facts speak for themselves. Nevertheless, the court finds that the defendant was the sole participant in the underlying crime. This was not an impulsive decision, nor was he peer pressured into committing the crime. He methodically walked through the school, picking and choosing who was going to die. He wanted to kill the innocent. The court finds this factor neutral. Next, the court finds that the incompetencies of youth, which affect whether the juvenile might have been charged with and convicted of a lesser crime, whether the juvenile was unable to deal with law enforcement or prosecutors, or whether the juvenile did not have the capacity to assist their attorney in their own defense, is a neutral factor. The court notes that defendant filed an insanity defense and subsequently withdrew the defense. Defendant has never been referred for competency. The court appointed 3 attorneys to assist defendant, which includes a legal guardian ad litem. The court appointed a legal guardian ad litem because defendant's parents are incarcerated at the Oakland County Jail. He has had more than adequate legal representation. Defendant can consult with his attorneys. He understands the charges against him, and he has had a factual understanding of the charges. In fact, he participated in his own defense and submitted to numerous evaluations and interviews from defense experts. Dr. King categorized defendant as a highly intelligent person. Defendant, in consultation with his attorneys and legal guardian ad litem, pleaded guilty as charged to all counts within the general information. There is no evidence on the record that defendant's youthfulness caused him to be charged with higher crimes versus lesser crimes, nor is there any evidence that he does not have the capacity to assist his attorneys in his own defense. Based upon his careful planning, maturity, and intelligence at the time of the offense, there is no evidence that defendant would have dealt with police or prosecution any differently if he was an adult. In fact, defendant specifically planned how he would deal with the police at the time of the shooting, surrender, and allow police to take him into custody. As such, the court finds this factor is neutral. Lastly, the court finds the juvenile's possibility of rehabilitation is a neutral factor. According to both the prosecution and defense, this case poses an issue of first impression in the United States because it involves the court weighing the Miller factors prior to sentencing and not on resentencing for a minor who's 15 years old at the time of the offense. Normally, in determining a juvenile's possibility of rehabilitation, the court has prison records or other records to rely on because the individual is before the court on resentencing for crimes in which they received life without parole sentences while minors. They are also known as juvenile lifers. Currently, defendant is 17 years of age and has been incarcerated since November of 2021. Therefore, the court has limited information regarding defendant's possibility of rehabilitation. So, the court finds it important to note his behavior prior to the underlying offense and his behavior thereafter in weighing his possibility of rehabilitation. Prior to the underlying offense, it is clear from the record that defendant was obsessed with violence. Defendant's internet history shows him visiting a specific violent website daily, months prior to the shooting. Lieutenant Willis described the site as an extremely graphic website that shows actual footage of crimes, murders, and assaults. On November 23rd, 2021, 1 week prior to the shooting, defendant searched for violent footage of brutal murders done with a machete and chopped machete compilations. On November 29th, 2021, the day before the shooting, defendant watched videos of several school shootings and their aftermath. The court reviewed school assignments and emails from school employees. Defendant drew pistols and rifles on several classwork assignments. An assignment asked defendant about his favorite books, movies, and TV shows. Defendant wrote in part that his favorite book is Resistance and Making Bombs for Hitler. A teacher caught defendant looking at different bullets on his cell phone while the teacher passed out essays. There were 93 pages of homework papers found in his backpack. There were guns drawn on at least 33 pages of homework. Additionally, the court has read defendant's journal. Defendant wrote, "If I would have never thought of the brilliant idea of shooting up the school, then I probably would have become a serial killer. I don't know which one is worse. LOL." Additionally, defendant wrote that he started a plan to kidnap, rape, and kill a young woman in his neighborhood, and that he found out she lived 5 minutes from him. He stated he would kidnap her with an industrial garbage bag, and he would then torture and rape her until he slit her throat. He further wrote about how he killed 8 infant baby birds by slowly torturing them until death. The court has reviewed videos that depict Defendant torturing a baby bird as he talked to it. He slowly killed the baby bird. In May of 2021, defendant texted his friend B about torturing baby birds. B advised defendant that most psychopaths start with small animals and eventually get bored with killing small animals and move on to killing bigger animals and then people. Defendant responded, "Yes, sir." It is important to note that defendant stated to B that most serial killers get their damage from their family or accidents. But I have no trauma from my past. I was just born this way. When Dr. Anker asked him what thoughts or feelings arose when he tortured baby birds, the defendant responded, "It's like a feeling between good and pleasurable. A relief feeling, feeling empowered. I don't know, it just felt good." There's other disturbing evidence, but it's clear to this court that the defendant had an obsession with violence before the shooting. As stated, the court also finds it appropriate to note the defendant's post-arrest behavior in determining his possibility of rehabilitation. Since the defendant's incarceration at the jail, he has attempted to obtain his GED. The court has read the report of defendant's legal guardian ad litem, Ms. McKelvey. Defendant passed all practice GED tests, including the math portion, with which he had struggled. Defendant was unable to take the GED test due to the inability to find a proctor approved to enter the jail. Per Ms. McKelvey, she believes if defendant had the opportunity to take the test, he would have passed. While at the jail, defendant has had several misconducts. On January 23rd, 2023, defendant was investigated for an incident where the juvenile next to his cell was able to use the GED tablet to post a video on Instagram from his cell. Defendant told deputies that he was the person who hacked into the protected password on the tablet, and that he also told the other juvenile inmate how to hack the tablet. Defendant advised deputies that he had hacked the tablet to play video games and read articles online regarding his case. This was not entirely true. Law enforcement was able to recover the tablet's deleted internet search history. Deleted search history showed that the defendant searched the same violent website he searched prior to the shooting to watch violent videos of the police, work accidents, and a prisoner killed during a fight in a cell. On February 10th, 2023, the defendant received his first violation for allowing another inmate to use his phone pen and allowing the other inmate access to defendant's phone credits and account. On the same day, jail staff observed defendant using a thin rope to wiggle a sugar packet to another juvenile inmate in a cell next to his. Defendant refused a deputy's order to give him the rope and instead flushed it down the toilet. In the jail, it is considered dangerous contraband. On February 11, 2023, defendant received a Category 1 violation for making contraband dice and a gaming board out of toilet paper and a cardboard box lid. Defendant received a fourth violation for failing to follow deputies' orders to remove trash bags on his windowsill. The deputies removed the trash bags and placed them on the floor, but defendant put them back up. The jail has also cited defendant for 3 additional rule violations that occurred on May 23rd, 2023, which included 2 violations of the jail's health and safety rules violation and 1 violation for destruction of jail property. The health and safety violations were for defendant's failure to keep his room clean and sanitary, whereas the destruction of jail property violation was because defendant removed a screw from the toilet seat in his cell. In sum, defendant's expert in corrections, Dr. Romanowski, noted that defendant has demonstrated moderate difficulty adjusting to incarceration at the county jail. Dr. Romanowski, when asked about his opinion regarding defendant's potential for rehabilitation, stated, "I've had very limited information, basically defendant's records in jail. But honestly, I think everybody has a potential for change. And I think Mr. Crumbley would be no exception to that rule. But I think he has to make that choice. He has to be the one to say, I want the change." Additionally, Dr. King testified that he believes the defendant can be rehabilitated. In support of his opinion, Dr. King referred to working in the field of brain injury for 25 years and his treatment of people with mental health. He further referred to neuroplasticity, which is the ability of the brain to create new pathways. Dr. King indicated that the defendant's brain is still maturing and his brain may not reach full maturity for another 10 years. The court finds that the evidence at this point shows that defendant's possibility of rehabilitation is slim. Defendant continues to be obsessed with violence and could not stop his obsession even while incarcerated at the jail. His obsession with violence is, in part, what caused defendant to commit the underlying offense. If defendant continues to be obsessed with violence in the jail, how can there be a possibility of rehabilitation? He continued the same type of behavior that he exhibited pre-incarceration. Although defendant may have received his GED if he could have taken the test, that alone does not show a possibility of rehabilitation. As defendant's own expert stated, defendant has to be the one who wants to change if he is to be rehabilitated. The evidence does not demonstrate to this court that he wants to change. Further, the court notes and considered Dr. King's testimony regarding rehabilitation. Dr. King testified that defendant's brain has not reached full maturity and therefore defendant can be rehabilitated. The court gives this conclusion little weight because it only focuses on defendant's brain maturing. It does not appear to consider other factors such as how will prison affect defendant's rehabilitation, or defendant's family support or lack thereof, or if defendant even wants to be rehabilitated. In short, the court cannot find that there is a possibility that defendant can be rehabilitated based solely on his brain maturing. Daily, there are people who have mature brains that commit heinous crimes and show no signs of rehabilitation or possibility of rehabilitation. The court finds defendant's possibility of rehabilitation is a neutral factor. In conclusion, the court finds that defendant's age and home and family environment are mitigating factors. The court finds the remaining factors neutral. This crime is not the result of impetuosity or recklessness, nor does the crime reflect the hallmarks of youth. Defendant carefully and meticulously planned and carried out the shooting. Accordingly, the court, having weighed all factors and noting the Michigan Supreme Court's admonition in Taylor, finds that the prosecution has rebutted the presumption by clear and convincing evidence that a sentence to life without parole is a disproportionate sentence. As such, this case will proceed to sentencing on December 8th, 2023. That is the order of the court. With that, counsel, we need to set another placement hearing because I have to still review defendant's placement every 30 days. I'm looking at October 20th, 2023 at 9 a.m. via Zoom for the next placement hearing. Does that work for counsel?
That's fine for the people, Judge. Thank you.
Works for
That's fine.
defense.
Yes, it does.
Thank you. With that, the court will enter this order forthwith. Is there anything else we need to address for the record this morning?
No, Your Honor.
No, Judge.
Thank you. With that, everyone's all set. Everyone have a great day. Thank you.
Thank you.
Oh, okay. So I'm gonna have to rewatch that end there. I'm not sure if did he just say that he can do life without parole or not? I guess that there was a lot of words, and I am exhausted, and I am smuggling my dog, which is making me sleepy. So, yeah, the sentencing will be December 8th. I will stream his sentencing as well. I do have to finish editing up the last of his Miller hearing videos, where you're going to hear from more experts, from doctors from the defense side. I just want to say to McGlitch, thank you everyone for joining me this morning. And oh, he did get, like, okay, he did get, that's what I thought he said, but I at the very end, I was like, wait, did he just say, because he said we're proceed with sentencing, but I'm exhausted. I have not slept since 5 a.m. yesterday morning. So, we will pick this case back up. Well, the next stage, which is December 8th. And I will finish editing the rest of the Miller hearing. If you guys go back and watch those live streams, you can actually hear from the victims, from the experts themselves. You can hear his video. He recorded himself the night before talking about it. So you can see exactly why the judge said he qualifies for life without parole. They read directly from his journal. And honestly, it's extremely disturbing. Not much gets to me, but this kid is disturbed. And he was very cool, calm, and collected about the whole thing. So it was purposeful. And he did plead guilty to all the charges. So he's not denying that he didn't do it. He's not trying to say that he was crazy when he did it. He said he did it. And here we are. He's now, his maximum sentence is life without the possibility of parole. The judge could give him a lesser sentence. He could say life with the possibility of parole, which I think is 40 years. There's different sentences it could be. So it's not a guarantee that it's life without, but I wouldn't be surprised if that's what he is sentenced to, given the severity of the tragedy that happened. Anyways, you guys, thanks for joining me. Don't forget to hit that like and subscribe button, and we'll see you next time.